How does entertainment law handle book-to-film adaptations? If you have ever wondered how your favorite book gets transformed into a movie, you are in for a treat. The journey from page to screen is a fascinating process, shaped by entertainment law and intellectual property rights. Let's break it down step by step. First, the process begins with securing the legal right to adapt the book. This involves negotiating and obtaining adaptation rights from the author or the rights holder. These rights are a form of derivative rights, meaning the film is based on the original literary work. Only the copyright owner or someone authorized by them can give permission for such adaptations. One of the initial steps in many adaptations is an option agreement. In this agreement, a producer acquires the exclusive right to develop the book into a film for a limited time, usually between 12 to 24 months. This option period allows the producer to assess the project's feasibility, secure financing, or attach a studio without fully purchasing the rights upfront. If the project moves forward, the producer exercises the option and buys the full adaptation rights under pre-negotiated terms. If not, the rights revert back to the author, who can then option or sell them to others. The purchase agreement for adaptation rights must clearly define the scope of rights transferred. This typically includes motion picture and television adaptation rights, which allow the creation of films or television shows based on the book. It also covers ancillary market rights for distribution in formats like home video or streaming platforms. Additionally, rights for sequels, remakes, or spin-offs derived from the original work are often included. Promotional rights may also be granted, allowing limited use of the book's content for marketing purposes. Authors and rights holders often negotiate to retain some control over adaptations. They may secure financial terms such as upfront fees, royalties, or profit participation. The cost of acquiring adaptation rights can vary widely depending on the book's popularity. Lesser-known works might sell for modest sums, while bestsellers can command substantial amounts. From a legal standpoint, entertainment law ensures that adaptations respect copyright protections. This means requiring clear permission for derivative use and defining the rights and obligations of all parties involved. Contracts must address credit attribution, compensation, timelines, and dispute resolution to protect both authors and producers. Entertainment attorneys play a key role in drafting and negotiating these agreements to prevent infringement and clarify ownership. In summary, entertainment law handles book-to-film adaptations by regulating the transfer and licensing of intellectual property rights through option and purchase agreements. These agreements specify the extent of adaptation rights, financial terms, and legal protections, shaping how literary works transition into visual media.